you don't necessarily have to tell your kids, hey, this is the will, and let them look at it, but you can tell them, hey, I keep my important documents in this place, or there's a safe, and here's where the key is. If something ever happens to us, you can go and find it there. The only place that I don't want people to put their wills or their trusts or other documents is a safe deposit box. It seems to be the go-to place that most people think of as the most safe there is, but the problem with that is, say my parents put their will in a safe deposit box, and then they tell me, hey, it's in the safe deposit box, if anything happens, let's go get it. Well, they both go down in a plane crash on their way to Hawaii, and I go to the bank and say, I need to get the will out. The bank will say, that's fine, but you don't have any authority to get into that safe deposit box. You need to go get appointed as the executor of your parents' will, and then come back with that letter from the judge saying that you've got the authority, and we'll open it right up for you. So I go to the judge and I say, Judge, I need to be appointed the executor of my parents' will so I can get into their safe deposit box. And he says, that's fine, but I need a copy of the original will before I can appoint you. And now you're stuck in this limbo land between the two, and there's a way around that, but it's complicated. It takes a lot of attorney's fees, and you get temporary papers and things that let you get in there. But if you don't put it in the safe deposit box, we can avoid all that problem. So that's the one place I don't like.
Can you appoint the lawyer who drew it up to act at the time you're dead?
Sometimes you can, but I'll be honest with you, don't trust your lawyer.
Oh.
I know we're lovable and most people trust us emphatically, but I would say that this is a document that you want to maintain control over. And a lawyer, if he's a family friend and you've known him for ages, then great, go ahead and do that. But otherwise, I would say let's keep it in the family, even if it's brothers and sisters, if it's not your kids. But keep it more family-centric. And that's not just because of the trust issue and going to somebody outside the family, but you're going to move. Circumstances are going to change. Your lawyer's going to retire. He's going to move. You just never know what the future's going to hold, and it's safer and more stable to keep it within the family and let them know where it is. And Jared, did you have a question?
Well, you were mentioning a safety deposit box. My mom, unfortunately, I had to access her safety deposit box for this very reason last month, and she was smart enough that she put my name on that safety deposit box for that very reason. So that's something you can do, Sandy, is rather than just having your husband and yourself having access to that safety deposit box, have a child or someone else. And I had the key, and so I just walked in there and said, my name's Jared, I need to get in my mom's box, and it went just like that, because I was responsible for that.
Yeah, that's absolutely an option, and your bank will tell you that too when you open the box. It's just that a lot of folks that I work with don't want their kids in there. There's other stuff that they don't want kids to have access to. So, depending on how you do it. Another common misconception is that folks will come to me and say, hey, Mom appointed me as her power of attorney, and it says I can handle all of her banking for her, so I'm good. The problem is that the day Mom passes away, that power of attorney is revoked. Or that only covers the time when you're still alive. Once you die, and really a power of attorney during your parents' life is just like being the executor of their will, except that they're still alive. It's just that it ends the day that they die, and you can't continue to use that. You've got to have the will to appoint an executor at that point. Yeah.
One thing that my mom did, because I went through this too as power of attorney and all that, is for a couple of years before she passed, I was a co-signer on her accounts, all of them, and so that really helped things after she died, taking care of bills and getting everything squared away.
Yeah, and that's one of the things we talk with folks about as part of the strategy for planning end of life, finances, is that if you have a child appointed on your bank account, and usually there's a right of survivorship provision that you can put in there, then when the parent passes away, all of that money can continue to be used in that bank account by the child. And that's really convenient for paying funeral expenses and for paying bills on like the mortgage or the utilities and that sort of thing. The other beauty of that is that it goes to that child. That money can be used by that child and basically inherited by that child without a will. It passes outside the estate because you owned it together, and when one person passes, the other person continues to own it. And it's a really convenient strategy for checking accounts, savings accounts. And if we can, we love to implement those kind of programs so that we don't have to use the will, and if something goes wrong with the estate.
Does that turn into an inheritance problem then?
Not necessarily, because you own it while you're alive. And it's just like my wife and I own a car together. If she passes away, I don't get taxed on the car, I don't lose the car, I don't have to pay anything toward it, I just continue to own it by myself. Same thing works with the checking accounts. And really, even with the will, Sam, I'll tell you, not a lot of risk of getting taxed on any of it or having to worry about that unless you've got more than $3.5 million. That's kind of the cutoff that we're working with right now.
Does that also apply to IRAs?
It can, if you set up your IRA right, and I usually encourage you to work with your investment planner on this, you can appoint death beneficiaries who inherit that IRA when you pass away, and it doesn't become part of your estate. In other words, it doesn't have to pass through your will, it just goes directly to them. And there's usually—
Is it taxed though?
Not necessarily. You know, you got to look at the individual circumstances, but usually that'll pass without taxes as well.
Okay.
Yeah, I mean, it's still going to bite into your $3.5 million that you've got that you can distribute, but it's not going to go through your will. You're not going to need to go to court and probate that and get a judge's appointment of an executor and that sort of thing.
Okay.
Any other questions? Okay, I'll let you go then. Thanks so much.